Welcome to Talk Trials. This is the deep dive where we don't just skim the headlines, we break down the landmark legal battles that shaped the world we live in.
We take the stack of transcripts, the appellate briefs, the dusty old depositions, and we really try to extract the story that actually happened inside that courtroom.
And today, we are looking at a case that is arguably the definition of a landmark.
Oh, absolutely. It changed environmental law, it changed maritime law, and it most certainly changed the way corporations think about liability.
It really did. We are heading back to 1989, Prince William Sound, Alaska.
A truly catastrophic environmental disaster.
11 million gallons of crude oil spilling into these pristine waters.
Yeah.
And you have a captain allegedly asleep at the switch, or at least not on the bridge where he absolutely should have been.
But, and this is the real hook for our deep dive today.
Yes.
The real drama we're analyzing didn't happen out there on Bligh Reef. It happened in a federal courtroom in Anchorage, Alaska.
That's it. This is the story of Exxon Shipping Co. v. Baker and the massive consolidated litigation that was known as In re Exxon Valdez.
And we all remember the images, right? The oil-slicked otters, the blackened beaches.
Of course.
But the legal battle was about a core tension that, it feels incredibly modern even today.
It does. On one side, you had a corporation that claimed it had paid its dues, it had cleaned up its mess, it had apologized.
And on the other side, you had a jury that felt a multi-billion-dollar message needed to be sent to what they called the mahogany boardrooms of Houston and New York.
That phrase is just incredible. Mahogany boardrooms.
It is. And the central question was one that, it kept lawyers up at night for almost 20 years.
Can a massive corporation be held liable for punitive damages? We're talking punishment money based on the reckless actions of a subordinate employee.
Or does the ancient law of the sea protect the owners from the sins of the captain?
The stakes were astronomical. We aren't talking about a slap on the wrist here.
Not at all. We're talking about the largest punitive damages award in history at the time, $5 billion, with a B.
And a legal fight that stretched from 1989 all the way up to the Supreme Court in 2008.
It's an epic. So let's unpack this, because to really understand that $5 billion number, you have to understand the setup.
Right. You have to go back to the beginning. The grounding happens March 24th, 1989. The chaos is immediate. The environmental damage is spreading by the hour.
But before we even get to the massive civil trial, the one that resulted in that historic verdict, there was a criminal phase. And I think a lot of people forget this part.
They do. It gets lost in the bigger story. But by 1991, the federal government and the state of Alaska had brought criminal charges against both Exxon Corporation and Exxon Shipping.
And this leads to a plea hearing before Judge H. Russell Holland.
This scene is just fascinating to me because you have the titans of industry standing there. You have Lawrence Rawle, the chairman of Exxon Corporation.
And Augustus Elmer, the president of Exxon Shipping.
Standing before a federal judge about to plead guilty.
It's a very formal, very tense moment. And Exxon was pleading guilty to violations of the Migratory Bird Treaty Act and, other environmental statutes.
But the strategy here was very, very specific. They wanted to cap the bleeding. They wanted to control the narrative.
Absolutely. The criminal penalty ended up being a $150 million fine. But, and here's the real kicker, $125 million of that was remitted.
Forgiven.
Forgiven, exactly, because of their cooperation and their cleanup efforts.
So when all was said and done, they paid a net fine of $25 million, plus another $100 million in restitution.
And this becomes crucial for their strategy later in the civil trial. Exxon's position from that point forward was essentially, we have accepted responsibility.
Look at us. We pled guilty. We paid the criminal fine. Most importantly, we have spent over $2 billion on cleanup. We have been punished enough.
That was the apology defense. They were trying to build a firewall. They thought, okay, we've done the mea culpa, we wrote the checks, now we can move on from this.
But of course, the plaintiffs, the thousands of fishermen, the native Alaskans, the landowners whose lives were just upended, they did not see it that way.
Not at all. They saw that criminal fine as a drop in the bucket compared to the sheer devastation.
So in 1994, the civil lawsuit kicks off. And this was a beast of a trial.
A beast is the right word. You're talking about hundreds of individual lawsuits, all consolidated into one massive federal case.
And the structure of the trial itself was unique. It wasn't just a simple guilty or innocent kind of thing. It was a phased trial.
Right. And this is important. Phase, I was all about liability. The question was Exxon reckless?
Then phase 2 was compensatory damages. So what was the actual calculable economic loss to the plaintiffs?
And then came phase 3, the big one, punitive damages.
And we have to clarify a legal distinction here because it drives the entire narrative of this case.
It's everything.
To get to phase 3, to get to that punishment money, the plaintiffs couldn't just prove Exxon was sloppy or, negligent.
Correct. Negligence is just carelessness. If I rear-end you at a stoplight because I was, fiddling with the radio, that's negligence. I have to pay for the damage.
Right. You pay for my bumper.
Exactly. But to get punitive damages, the plaintiffs needed to prove recklessness. They had to prove that Exxon knew there was a high risk of a disaster like this and just proceeded anyway. Willful indifference.
It's a much higher bar to clear.
A much, much higher bar.
So let's go inside the courtroom for phase 9, the battle for recklessness. The plaintiffs had really 2 main prongs of attack. The first and the most obvious one was Captain Joseph Hazelwood.
The drunk captain narrative, it was the most visceral part of the case, the part everyone could understand.
And the testimony about Captain Hazelwood's alcoholism was extensive. But there's this one moment in the cross-examination that I think perfectly encapsulates the plaintiff's strategy.
Oh, the sidewalk cafe exchange. It's just classic courtroom drama. You can't write this stuff.
You really can't. So Hazelwood is on the stand. He's being cross-examined about his drinking right before he boarded the supertanker.
And he's clearly trying to minimize it. He's trying to make it sound casual, harmless. He keeps referring to the place where he was drinking as a sidewalk cafe or a lobby.
It sounds so innocent, doesn't it? A sidewalk cafe, you picture a little bistro table, maybe a croissant and a coffee.
Exactly. But the plaintiff's lawyer, he wasn't having any of it. He just keeps pushing him. He confronts him with his own deposition testimony.
And finally, Hazelwood has to admit it. He says, okay, it was a lobby lounge bar. An open-air bar.
It just destroys his credibility on that point. Because he's been caught trying to spin it.
And then you layer on the other witnesses. You have people testifying they saw him drinking vodka before he got on the ship.
You have experts like Dr. David Smith diagnosing him with alcoholism and discussing the very high risk of relapse for someone in his position.
But here's where it gets really interesting from a legal perspective. Proving the captain was drunk wasn't actually enough to stick Exxon with billions in punitive damages.
No, not by itself. This is a key point. You can have a rogue employee do something absolutely terrible, and the company is liable for the damage, yes, but not necessarily for the punishment.
Right. It's like your example. If a delivery driver for a big company gets drunk and crashes a truck, the company pays for the truck and the medical bills.
But they don't necessarily get hit with a massive punitive fine unless the company itself did something wrong.
Which brings us to the second prong of the plaintiff's attack.
Precisely. The corporate complicity argument. The plaintiffs, led by a lawyer named Brian O'Neill, had to prove that Hazelwood wasn't just some rogue actor who went off the rails.
They had to prove that Exxon knew that the corporation itself was reckless.
And this is where the managerial agent theory comes into play. It's a bit of legal jargon, but it's crucial.
Break it down for us.
To hold the corporation itself liable for punitive damages, the law requires that a managerial agent, someone in a position of authority, was complicit in the recklessness.
So it can't just be the guy on the factory floor. It has to be someone who represents the company's will, in a sense.
Exactly. And the plaintiffs argued that the whole system at Exxon was broken. They brought in evidence showing that Exxon executives knew, or certainly should have known, about Hazelwood's well-documented drinking problems.
They pointed to his 1985 rehab stint, which the company paid for.
Right. And they argued that he wasn't properly monitored afterwards. There was testimony suggesting that executives, essentially looked the other way, that they put profits and convenience ahead of safety.
And what was Exxon's response to this? They tried to pivot, right?
They did. They tried to change the subject. They argued this wasn't about alcohol. This was about fatigue. The crew was tired.
Which, that feels like stepping on a rake in the middle of your own yard.
It backfired spectacularly because the immediate next question from the jury's perspective has to be, well, if the argument is the crew was too tired to operate this massive, dangerous ship safely, who sets the staffing levels?
Who sets the schedules?
Who decides how many people are on that crew? The corporation.
So the fatigue defense just ended up implicating corporate policy even more deeply. It was a huge mistake.
A huge own goal. And so the jury buys it. They come back with a verdict in phase 1. They find Exxon was reckless.
Check. Box 1 is ticked. Now we move past phase 2, the compensatory damages, and go straight to phase 3, the punitive damages fight. This is where the gloves really came off.
This is where the emotional temperature of the trial just skyrocketed. Phase 2 had established the actual economic loss to the plaintiffs. It was around $287 million.
A lot of money, but not company killing money for a giant like Exxon.
No, Phase 3 was different. Phase 3 was about sending a message.
Brian O'Neill's closing argument in Phase 3 is, it's legendary in legal circles. He didn't just talk about oil and dead fish. He talked about arrogance. He talked about corporate culture.
And he used the incredible phrase you mentioned earlier, the mahogany boardrooms.
It's such a powerful image.
It is. He told the jury that the only way to get the attention of executives in New York and Houston men who would never set foot on an oil beach in Alaska was to hit them with a fine that wasn't just a hiccup on their quarterly financial statements.
He also used the white shirt argument. This was brilliant.
Explain that.
And he pointed out that Captain Hazelwood, the guy in the blue work shirt, he got fired instantly.
Right.
But the executives, the guys in the white shirts who oversaw the entire fleet, who cut the staffing to save money, who ignored the monitoring reports on their relapsed alcoholic captain.
Yeah.
What happened to them?
They got bonuses. They got raises.
Exactly. It painted this stark picture of two different sets of rules. One for the workers on the ground and a completely different one for the bosses in the boardroom.
It's an incredibly effective argument for a jury. And then, as if to prove O'Neill's point for him, Exxon made a tactical error that just played right into his hands.
They put their president, Lee Raymond, on the stand.
Oh, this was a disaster. I've read the transcripts of this testimony. It is painful to read.
It's a case study in what not to do.
It really is. Raymond was the president of Exxon Corporation. He's the top guy. And on the stand, under oath, he admitted that he didn't know key details about the spill's cause. He didn't know the specifics of Hazelwood's monitoring or lack thereof.
He came across as completely detached, willfully ignorant. It looked like he didn't care enough to even learn the basic facts of the worst disaster in his company's history.
And the plaintiff's lawyers used that to hammer home their point. They argued that this wasn't remorse, this was arrogance.
They argued that painting a smokestack Exxon actually changed the name of the shipping subsidiary and repainted the smokestacks on their ships didn't equal accepting responsibility.
O'Neill called it a mockery of responsibility, just window dressing.
But the defense had a strategy too. You have to give them credit. James Neal, their lead lawyer, he was a heavyweight. He didn't get up there and try to say the spill was a good thing.
No, his argument was much more subtle. It was essentially, we're sorry, and more importantly, we put our money where our mouth is.
The we cleaned it up defense.
That was the core of it. Neal emphasized over and over the $2.7 billion Exxon had already spent on cleanup and claims. He argued that no company in history had ever responded so massively to a disaster they caused.
His closing line was incredibly memorable. He looked at the jury and said, Prince William Sound won, and the trial lawyers lost.
A bold move. He was trying to frame the whole push for punitive damages as just greed on the part of the lawyers, arguing that the environment was already being taken care of.
And he also used the double jeopardy argument, not in the strict legal sense, but in a moral one.
Right. Saying, look, we already paid the criminal fines. We paid for the massive cleanup, punitive damages on top of all that are just piling on.
And finally, he tried to bring it back to Hazelwood, the rogue employee defense. He basically said, we have 80,000 employees. We can't watch every single one of them every second of every day.
He was trying to distance the white shirts from the blue shirt to put all the blame on one guy.
But the jury in Anchorage, Alaska, who had lived through this, they didn't buy it.
No, they certainly did not. The verdict comes down.
And it is a thunderclap.
First, the $287 million in compensatory damages. That was expected.
Then a $5,000 judgment against Captain Hazelwood personally. A token amount, really.
And then the number that shook the world, $5 billion in punitive damages against Exxon.
At the time, that was roughly equal to one entire year of Exxon's net profits.
It was designed to sting. It was designed to be exactly what O'Neill asked for. Not a hiccup, but a body blow, a message.
It was a moral condemnation delivered by a jury of their peers.
But as we know, in the American legal system, a jury verdict is very rarely the end of the story. Especially
when $5 billion are on the line.
And this begins what can only be described as the appeals roller coaster.
If you were a plaintiff in that case, a fisherman waiting for that check to rebuild your life, you were in for a long, long wait.
Nearly 2 decades of waiting. The case just bounced between the district court and the Ninth Circuit Court of Appeals for years and years.
Judge Holland, the original trial judge, he initially upheld the $5 billion award.
He did. But then the appeals court would say it was too high, that it was excessive. So he reduced it to $4 billion. Then it went back up and he adjusted it to $4.5 billion.
It was this constant tug of war over the math of punishment. What's the right number to punish but not destroy?
And finally, in 2008, 19 years after the spill, it reaches the highest court in the land, the Supreme Court.
Exxon Shipping Co. v. Baker.
But here is the fascinating thing, and it's a bit counterintuitive. The Supreme Court didn't take the case to redecide if Exxon was bad or if they were reckless.
No, the jury's finding of fact on that was settled.
Exactly. They took the case to decide some very specific and frankly very old questions of maritime law.
And this is where we have to dust off the history books.
Yeah.
Because suddenly we aren't talking about 1989 anymore. We're talking about 1818.
Yes. We are talking about the Amiable Nancy.
I love that name. It sounds like a children's book.
It does. But it's actually a case about privateers and piracy on the high seas.
What happened in the case?
Well, in 1818, the Supreme Court heard a case where the crew of a privateer ship, which were basically state-sanctioned pirates, robbed a neutral vessel called the Amiable Nancy.
Okay.
The owners of the privateer ship, they weren't on board. They were back on land, minding their business. And the court ruled that, yes, the owners had to pay for the stolen goods.
The compensatory damages.
Right, but they did not have to pay punitive damages for the unauthorized rogue acts of their crew.
So fast forward almost 200 years, Exxon's lawyer, Walter Dellinger, goes to the Supreme Court in 2008 and says, look at the Amiable Nancy. This is the tradition in maritime law.
He argued that you don't punish the owner for the rogue acts of the captain unless the owner specifically directed it or was complicit.
Dellinger's argument was brilliant in its own way. He argued that maritime law is unique. It's designed to promote commerce and shipping, and it has always had this special protection for the absent owner.
And he also argued for a hard limit on punitive damages, a predictable ratio.
And on the other side, you have Jeffrey Fisher, who is representing the plaintiffs, the fishermen.
And he's making the opposite argument. He's basically saying, Your Honors, with all due respect, this isn't 1818.
We aren't talking about a wooden sloop with a handful of sailors. We are talking about a corporate-owned supertanker carrying a substance that can destroy an entire ecosystem.
Fisher argued that these modern corporate structures make the whole absent owner defense obsolete. He said a captain of a vessel that size, with that much responsibility, is a managerial agent.
He's effectively the corporation while he's at sea.
Exactly. He argued that modern environmental statutes and the just sheer scale of the risk meant that the old rule shouldn't apply in the same way.
And the oral arguments were apparently intense. The transcripts show the justices, particularly Justice Souter and Chief Justice Roberts, really wrestling with this line.
They were. Where do you draw the line between a CEO and a captain? Is a captain managerial when it comes to setting corporate policy, or is he just executing it?
Chief Justice Roberts asked, how do you draw the line between the CEO and the cabin boy? It sounds like a funny question.
But legally, it's the whole ballgame, because if the captain is just another employee, like the cabin boy, then maybe no punitive damages against the company. But if he's a manager, the firm pays.
And in the end, the Supreme Court, they kind of split the difference in a way that really, really deflated the plaintiffs.
They did. It was a very clever and, for the plaintiffs, a very painful ruling. They didn't strike down punitive damages entirely. They actually ruled that, yes, under maritime law, a corporation could be held liable for the reckless acts of a managerial agent like a ship captain.
So Jeffrey Fisher won that point. A big win, theoretically.
He did. But then the court looked at the number, the $5 billion.
And this is where they established the 1:0.1 ratio.
Exactly. Justice Souter, who wrote the majority opinion, looked at the history of maritime law and common law and essentially decided that an outlier verdict like $5 billion was too unpredictable for the world of commerce.
He said it created too much uncertainty.
Right. So she established a new rule, but only for federal maritime cases. Punitive damages should generally be limited to a 1-to-1 ratio with the compensatory damages.
So because the actual economic damage, the compensatory part, was roughly $500 million after all the adjustments over the years,
the punitive damages could only be roughly $500 million.
The $5 billion award was slashed down to $507.5 million.
Basically 10 cents on the dollar of what the jury awarded.
For the plaintiffs, after waiting nearly 20 years, this had to be a crushingly bitter victory.
It was devastation. I mean, you have to remember, by 2008, many of the original plaintiffs, the fishermen who lost their livelihoods back in 1989, had passed away.
Their families inherited the claim.
Right. And the payout, when it finally came, was just a fraction of what that jury in Anchorage intended to give them.
So what does this all mean? When we look back at the legacy of the Exxon Valdez trial, obviously it changed how we transport oil. We have double-hull tankers now because of it.
Huge practical changes.
But legally, what did it leave us with?
Well, it left us with this very specific, some would say archaic anomaly in maritime law. The 1-to-1 ratio is now the standard in federal maritime cases. It's the Exxon rule.
And it highlighted this tension that we see all the time in the legal system?
Yeah.
The tension between a jury's desire to send a moral message.
And the appellate court's desire for economic predictability and, proportionality.
It also brought that concept of responded at superior, which means let the master answer, into really sharp focus.
It really did. It showed just how difficult it can be to pin punitive liability on a massive modern corporation for the acts of a single employee, especially in federal courts compared to some state courts.
And you have to think it changed corporate governance, right?
Yeah.
The trial exposed this huge gap between the safety policy on paper and the safety practice in reality.
Absolutely. The whole managerial agent debate forced corporations to realize that they can't just write a safety manual, put it on a shelf, and walk away.
If they delegate that kind of immense authority to a captain or a site manager, they are potentially on the hook for that person's recklessness.
It forced a lot of companies to rethink who they empower and how they monitor them.
Which brings us to the moment of judgment. We've looked at the evidence, we've looked at the arguments, the strategies, and the final outcome. Now, it's time for us to take a seat in the 10th chair.
All right. Sitting as the 10th chair, we have to ask the ultimate question. Was justice served in the case of the Exxon Valdez?
I think looking at the delay alone, it's incredibly hard to say yes.
I agree.
Justice delayed by nearly 2 decades is, in so many practical ways, justice denied. A 90% reduction in the award after 20 years of litigation. It feels less like justice and more like a win for the strategy of attrition. Just wear them down.
You're right, and I think we have to look really critically at the definition of punishment. The defense's core argument, and it's one that seemed to really sway the Supreme Court, was that the $2 billion they spent on cleanup was punishment enough.
We paid to clean it up, so why punish us more?
Exactly. But that argument, to me, it conflates restitution with punishment. They're two different things.
They're completely different. If I break your window, paying to fix the window is restitution. It's just making you whole.
It puts you back where you were before I acted.
It doesn't punish me for throwing the rock in the first place. The cleanup was a legal necessity for Exxon. It was a public relations survival tactic. It wasn't a fine.
The jury got that. The jury correctly identified that punishment requires something more, something beyond just fixing the mess. It requires a sting.
And what about the corporate liability? The white shirt shield, as O'Neill called it.
Well, I think the jury's instinct was sounder than the appellate court's math on that one.
How so?
The managerial agent defense, if taken to its logical extreme, is just dangerous in a modern world. If corporate liability for punitive damages only attaches when the board of directors practically steers the ship themselves, then corporate accountability becomes almost impossible.
You create a shield of plausible deniability for the people at the very top.
Precisely. The failure to monitor a known alcoholic captain in charge of a supertanker was a systemic corporate failure. That was the jury's finding. It wasn't just a rogue employee error.
So in your view, the trial court worked as intended. The jury heard the evidence and sent a clear message.
I think so. But the appellate system, especially the Supreme Court in this case, prioritized economic predictability over that jury's moral condemnation.
So to recap, the Exxon Valdez trial was this epic battle between the checkbook defense, we paid for the cleanup, and the moral mandate, the idea that recklessness requires real punishment.
From a drunk captain in a bar in Valdez to a detached CEO on a witness stand in Anchorage, the trial just exposed this massive gap between corporate operations and true corporate responsibility.
Now, while the Supreme Court did set a precedent for predictability with its 1-to-1 ratio, it left open a really big question.
Which is
a predictable fine, a fine that a company can almost budget for as a cost of doing business, ever really enough to deter a multi-billion-dollar entity from taking profitable risks?
That is the question, isn't it?
And remember, our analysis including the judgment offered in the 10th chair, is commentary for informational and discussion purposes only. It is not legal advice.
We'd really love to hear your thoughts on this one. Does a 1-to-1 ratio make sense to you as a cap, or does it strip the jury of its power to truly punish corporate recklessness?
Thanks for listening to Talk Trials.
We'll see you for the next deep dive.